What is a durable power of attorney, and why would I want or need one, and why is it more important now than ever? The average person is usually not clear on what the term power of attorney means or the significance. Even for those that have one or have studied the document, it's not often clear exactly who serves what role and why. A durable power of attorney, which is also called the financial power of attorney, is a document that empowers another individual to carry on your financial affairs in the event you become disabled or incapacitated. Without a durable power of attorney, it may be necessary for one of your loved ones, including your wife or adult child, to petition a court to be appointed guardian in order to make decisions for you when you are incapacitated. This guardianship process is time consuming, expensive, and often costing thousands of dollars, and it can be emotionally draining for your family. When you create a durable power of attorney, you give this duty to a trusted relative, loved one, friend, or professional to help ensure your financial matters are taken care of and your wishes are followed. Financial powers of attorney give the person the power to manage your money and assets. When you appoint another individual to make financial decisions on your behalf, that individual is called an agent. Most people choose their spouse or domestic partner, a trusted family friend, or family member. Since you're an adult, Florida law does not allow you to automatically be able to have anyone act for you. It requires that you must appoint them through the use of a financial power of attorney. What are the limits of the power of the agent? It helps to understand what is being asked of the agent under a power of attorney. A person appointed to the role becomes a representative of the principal's finances. In effect, they gain permission to step into the shoes of the principal and act on their behalf. You determine what their power and authority is. If you choose to have a limited power of attorney, though, the agent's power is very specific and restricted. Normally, their authority to act on your behalf is limited to the specific transaction or actions outlined in the limited power of attorney. An example would be executing a real estate deed on behalf of an out-of-town principal, for example. This kind of power of attorney offers stricter parameters on what the agent may do on behalf of the principal. What duty does the agent owe to you? Regardless of which power of attorney, agents must act as a fiduciary to the principal. This means the agent must operate in good faith, with the best interests of both the principal and their affairs in mind. When making any decisions, the agent is required to consider the choice the principal would make. Those who abuse their power in this role can be held liable for their actions. Should an agent need to act on behalf of the principal, it is important that the agent document everything they do. Documentation is the best way to answer any questions or challenges to the agent's actions. Agents should not commingle their finances with that of the principal's. Who can establish a power of attorney? Generally, any individual over the age of majority and who is legally competent can establish a power of attorney. Who may act as an agent under a power of attorney? In general, an agent or attorney in fact may be anyone who is legally competent and over the age of majority. Most individuals select a close family member such as a spouse, a sibling, or an adult child, but any person such as a friend or a professional with an outstanding reputation for honesty would be ideal. Can I have more than one person named? You may appoint multiple agents to serve either simultaneously or separately. Appointing more than one agent to serve simultaneously can be problematic because if any one of the agents is unable to sign, actions may be delayed. Confusion and disagreement between simultaneously agents can also lead to inaction. Therefore, it is usually more prudent to appoint one individual as the primary agent and nominate additional individuals to serve as alternate agents if your first choice is unwilling or unable to serve. When is the power of attorney effective? Under a durable power of attorney, the benefits and responsibilities of being an agent under a power of attorney start as soon as the principal signs off. However, most principals do not expect an agent to use this tool unless they become incapacitated.